case, Your Honor. I know you've read it, heard what you just said. I focus then on the fact that Baker was not a gang case, not a RICO case, not a conspiracy case. A RICO conspiracy case, I understand that, but it did involve the playing of just a video, what was deemed by the Supreme Court of Georgia, a rap video, no lyrics, because the lyrics were not understandable. But the reason that I found it important to raise, on behalf of Mr. Williams, our supplement to the motion, in limine number 2 motion to strike, filed on the 6th day of March 2024, the day after Baker was decided, was that the highest court, and it's a 7-2 opinion in Baker, really took to task the use of a video, just the images. The video was, and I'm quoting from Baker, the video was glorifying violence and gun violence and a sort of street life, glamorizing it. And then I go to footnote 16, and I've given the Honorable District Attorney already a copy, and I've given this Honorable Court and the Honorable Mr. Kearns a copy of the 3 cases that are in footnote 16, where the Supreme Court of Georgia wrote, "We note that the probative value of the rap music video was further diminished by the state's failure to present any evidence that Baker's performance of Crawford's rap song was not wholly theatric." And then they cite the United States versus Gamory, G-A-M-O-R-Y, which I'll get to, Your Honor, and they write, explaining that a rap music, they being the Supreme Court of Georgia, explained that a rap video was minimally probative under Federal Rule 403 because there was no proof that the appellant authored the lyrics or that the views and values reflected in the video were in fact adopted or shared by the appellant. So I thought that was important because here the state is trying to introduce numerous lyrics and videos.
Let's talk about that. Baker arguably involves the introduction of a video which there's little nexus to what they're trying to prove. Could you discuss for me how that, in this particular case, the state has said, look, we're gonna tie this to some aspect of membership, of leadership, and other things that are required to be proven under the gang statute. So tell me how, if you could distinguish that for me or talk about that, because I think the facts in Baker are a little bit different than the facts in this particular case. And remember, I've also told you it's subject to foundation. So, so address that for me if you wouldn't mind.
Sure. So I don't believe that the state will show any type of nexus, and in New Jersey versus Skinner, S-K-I-N-N-E-R, which is 95A as in Atlantic 3D 236 2014, cited, the reason I'm using it is cited in that footnote 16, and in the copy of the copy that I gave this Honorable Court, the printed copy this morning, and the parties in page 11 of 15.
Are you talking about Skinner?
Yes, it should be on top, Your Honor. New Jersey or it's versus Skinner. And on page 11 of 15, it's footnote 5, which is at the bottom right. And I think that answers for me the question, and that was cited by our highest court in Baker. And it specifically says in that footnote, of course, rap lyric evidence that provides direct proof against the defendant, such as an admission or details that are not generally known and dovetail with the facts of the case, should be analyzed for relevance under 401 and evaluated under 403 standard for prejudice, and not the standard for prejudice under a Cofield analysis. And then they cite another case from New Jersey, recognizing intrinsic nature of evidence that directly proves charged offenses as excluded from 404B's analytic framework. A jury need not be shielded from a defendant's confession simply because it conveyed in a rap or other artistic setting. And what I'm saying here is, Your Honor, the state can't do that. When we had that last hearing, it went till late at night, the state was saying things like, and I'm just using out of the indictment, I ain't killed nobody, but I had something to do with that body. They just said, there it is, Judge. That's what we're saying. We're saying that Mr. Williams' hands are always clean and he has other people kill for him because he's the leader. That lyric, first of all, is used in other songs, which I've mentioned to court previously. But in addition to that, that's not something that's unknown. There's no details. There's no nexus. This honorable court, to admit that, is just admitting the artistic work, doesn't know if it points to any type of killing. It just goes to propensity. And I believe under Baker, 403 analysis should shield it. So I hope that answers your question, but that's what Skinner says to me from New Jersey. That was cited by our highest court. In Commonwealth of Massachusetts versus Gray, which is another case I've given this honorable court and the parties, and it's on page 12. Oh, I'm sorry, it's 978 New England, or New Northeast 2D, NE 2D 543, 2012. On the opinion that I've given to this honorable court and the parties on page 12.
Up 13?
Yeah.
Okay.
On the left-hand side, the first full paragraph, it's in the center of 12. The video, I'm just reading what the court wrote from New Jersey. The video was produced at an unknown point in or before 2005 and was available on a commercial website promoting rap artists. The defendant did not write or perform the lyrics or produce the video, and it was not found in his possession. The lyrics show no connection to the defendant that would suggest that they were, biographical, or otherwise indicative of his own motive or intent at the time of the shooting. Yet the video was admitted specifically as an asserted statement of gang allegiance by the defendant based on Sheehan's, which is S-H-E-E-H-A-N, apostrophe S, voir dire testimony to its meaning. Even if the video had contained direct statements of the defendant's gang allegiance, we are not persuaded by the opinions of courts in other jurisdictions that view rap music lyrics not as art, but as ordinary speech, and have allowed their admission in evidence as literal statements of fact or intent without contextual information vital to a complete understanding of the evidence. And to answer your question, I hope I'm answering, but the state can't do that. They didn't proffer to you anything that would associate these lyrics with a certain crime. The closest they came is they told the court that trestle tree, that Jeffrey Williams said the word trestle tree, which is a section, a street where crimes were committed in this case. The fact that he is using trestle tree in a song certainly cannot be that he's somehow involved in that crime. In addition to that, the prosecution has spent 4 months showing or trying to show that Mr. Williams is the leader of this gang. They have put on over objection Mr. Bean's recorded statement with Detective Quinn saying that Jeffrey Williams orders, he commands Mr. Murphy to do something. They put on Trontavious Stevens, who said inconsistently, but said Jeffrey Williams is a member of the gang. They put on that Jeffrey Williams is the slime, the big slime, King Slime rather, excuse me. They put on Detective Belknap. They are going to use over objection Detective Gaither as a gang expert on YSL. They're going to use Detective Dennis as a gang expert on YSL over objection. They're going to use Investigator Viverito as a gang expert on YSL, and all of them make, for certain, over objection, Mr. Williams the head of this supposed criminal organization. So why did the lyrics have any probative value if it's simply cumulative? I'm trying to answer your question, but my point is to use the art, to assume that that is statements that the state argued are confessions. That's what they said. These are confessions. They said that we didn't go out and find them. Mr. Williams, handed them to us. These are his inner workings of his mind. But it's an artistic industry that our courts now, for the first time, this is the first time in Georgia, our court has said in footnote 16, we got to be careful. And they cite to these cases that say you got to be careful. The next case cited by our highest court is United States versus Gamory, Gamory, and that's 635 F 3rd 480. It's 11th Circuit 2011. Again, it's in footnote 16 of the Baker case. And on the copy of the opinion I give in this honorable court and the parties, it's in Division B, as in Barry or Bravo, and that starts on page 7 of 11, Your Honor.
So, obviously, I'm objecting to the admission of both of these videos, and I think the analysis is similar for both. First, I think we need to ask what the state's theory of admission is. And the first question that you asked Attorney Steele about his issue, I think is important to ask in this case. What is the direct nexus? What nexus is there to any allegations in this indictment, any crimes? Regarding the video Smile It Off, I will concede it is listed as an overact, 95, okay? And I'll get back to that. My stance is just because the state pleads something as an overact doesn't make it automatically admissible. If I had a client who said something in a confession that was deemed inadmissible for Miranda violations by the court, and the state decided to put in their indictment as an overact, it wouldn't overrule the gatekeeping function of the court to keep it out. So, that is listed as an overact, but it has no ties and no nexus to any substantive offenses. Essentially, in that rap video or in that verse, I believe that you can see my client. Now, I know the state has pointed out in previous pleadings, he is allegedly wearing a YSL necklace, and he's allegedly wearing red. What does he say? He says, he talks about going to, I believe he says the plug, but essentially robbing drug dealers or drug distributors. He boasts of keeping a stick, which common parlance is an assault rifle, on him. And he says, I just beat a murder rap, paid my lawyer $30 for that. Now, none of those statements, robbing drug distributors, that has no direct nexus to any substantive charges in this case. Keeping a stick has no direct reference to any charges in this case. I just beat a murder rap, paid my lawyer $30 for that. Now, I think it's fair to say that that is most likely a reference to being wrongfully arrested back in 2015 for the murder of Donovan Thomas. He was arrested in October of 2015. He stayed in jail for a long time as his co-defendants' cases had their preliminary hearings, were dismissed. Eventually, the state dismissed cases against all 3 other individuals that were charged in that case, along with Mr. Stillwell. Mr. Stillwell was granted bond. And as artists do in their expression in hip hop, it may have been a certain level of fictionalization because we know, in fact, it was not dismissed. He was, in fact, on bond. But that is not in any way an admission of guilt. That is just a statement that I was wrongfully arrested in the past. I paid my lawyer for that. I have no idea how much he paid the lawyer. It wasn't me at the time. But, you know, that's just an expression of artistic freedom, and also, but even if it is based in some facts from his past, it's not an admission to anything. It's completely irrelevant. It's just saying I've been arrested and I beat the case. And it becomes harmful with the next line where he says, me and my slime's above the law. It becomes the idea of bragging, of boasting. That's where the prejudice comes in. To the jurors, oh, you think you're above the law because you're rapping about being wrongfully arrested. Now you're free. And now we get to judge you for that. It's very prejudicial. So we have trying to rob them, drug dealers, keeping a stick, and I'm above the law. Okay? No evidentiary value to any substantive charges in this case. Not an admission, it's not intrinsic, it's not 404B, even though we were never given notice of it being 404B. It's just wholly irrelevant to this case, except for maybe, I concede, the slight relevance, the scant probative value of wearing a YSL chain. I'm not even going to concede wearing red has any probative value to anything, but wearing the YSL chain. And we'll get to the balancing test later on. Regarding the video from where we're saying possibly 2015 in the car, Mr. Stillwell on that is calling out.
Mr. Schardt, before you move on, let me ask you a question.
Yes.
You don't believe that your client's statement potentially of I beat a murder rap might be an admission?
He was, it's not in dispute. He was arrested for murder.
Okay.
I mean, that's known. We're going to talk about it. He was wrongfully arrested for murder in October of 2015.
Isn't that one of the predicate acts that the state has alleged in?
It is, but I don't see how acknowledging that you were arrested for the murder and either released or
But you
beat it.
sang about it though, and isn't that for the jury to? I mean that's directly probably one of the more stronger things that that the courts heard in terms of just.
So if
I mean, involvement because they can look at it for several reasons, for a couple of reasons. One, he's membership and the fact he's wearing a YSL chain.
Okay,
Two, that he's wearing red, and three, that he's rapping about a potential issue that he's been involved in. So, two, and if it's alleged as part of one of the overt acts, of course, the state's got to lay a foundation as to that, but.
And I'm going to go into 1 and 2, and I'm not going to push back on that, Judge, the chain and if wearing red, but the referencing. I mean, if I write a book, if I'm arrested for murder and I write a book, talk about, well, I was arrested for murder, and this was what it was like for me in Rice Street, and this is and I beat the case, and then the state, and I don't say anything about the allegations. Nothing about guns, nothing about motives, nothing about anything. And then the state charges him with murder 10 years later. I wouldn't see the relevance of me in a book saying, oh, I was arrested for this. We all know he was arrested. He was arrested for murder. He was charged with murder. That's a known fact. I don't know why we need this song to be admitted to show that he was charged.
Was there a trial on the murder?
No, this is the trial.
Okay, all right. So basically, your client's alleged participation in this or commission of this murder is fairly contained with this indictment, correct?
Correct.
Okay, so why wouldn't that be considered potentially a statement against interest or?
Because it's not against interest. He's just stating a fact. He was charged with murder.
Okay.
I mean, that's not against interest.
I know, but you have a choice as to whether or not you want to say anything or. One of the views of our Constitution is, hey, you can, a couple things. You certainly have a freedom of speech, but certainly you have, advice of counsel, and certainly you have the issues of whether or not, whether or not you make statements that are against your interests. And especially if you put them in a song, relative to what you potentially might have been involved in, not just, and I'm saying that nexus is something that is a little bit. Baker speaks to where the court's got to look at in footnote 16. That it's not like he's not involved in the video. He's prominently posted in the video, and it's not like somebody else is attributing those statements to him.
No.
So I mean,
Well, okay.
I think it's a little different.
Well, I disagree
Sure.
that it's relevant, but I will also talk about the probative value in a second, okay? To the extent there's probative value, because there also needs to be 403 balancing. I don't believe it's relevant, but we'll talk about the probative value.
Okay, but remember, in Baker, the person wasn't even in the video, right?
He was,
In Baker?
yes, he wasn't the artist. I think the gentleman's name was No Cap, was the artist. Mr. Kobe Crawford. The gentleman, Mr. Baker, was in the video dancing with a firearm.
Yeah, I mean, but here's the thing about it is, but that particular individual neither authored the lyrics or the views or values reflected in the video were adopted or shared by the appellant. So, a little different. I mean, I think it's a little stronger in this particular video. I mean, and that's the jury's determination. This is just the court's threshold issue. But if I'm rapping about, I beat a murder rap, okay? That's pretty, I mean, the jury could consider that as a statement against interest, right?
No.
Okay, well,
It's
we're gonna disagree. We're gonna disagree about that.
So if I said,
Well, it wouldn't be wise for one to say I beat a murder rap and the prosecution's still open.
whether it was wise or not is a different
Well,
issue. If he contacted me before
You probably would have told him, don't say that, right? Or
but
don't
that
write
doesn't
it.
make it relevant.
Well, it's relevant for the jury to determine whether or not he committed a murder.
Saying that you were arrested and let's put context.
Okay, but
to
remember,
this.
there's other linkage that has to go on with that. In Baker, it's a little different. The courts are kind of telling us, look, you have to show some particular nexus, and you have to make sure that I mean, and they had beef in this particular case because it was minimally probative. Okay.
What is I'm
In
failing.
this particular circumstance, I think that they've tied, along with the client wearing red, client wearing a YSL T-shirt, shirt, and then rapping with other arguably members of YSL about a potential crime that he may or may not involved in. Now, the jury can decide that that's not what it stands for, and they're gonna in weighting the evidence. But under 403 in Baker, the 11th Circuit, as Mr. Steele pointed out in Gamery, 635 F 3rd 480. The rap video in this particular case was minimally probative under 403 because there was no proof that the appellant authored the lyrics or the views and values reflected in the video were in fact adopted or shared by the appellant.
Well, Gamery deals with a different set of facts, but just because my facts don't match Gamery doesn't mean the opposite conclusion.
No, but it tells me it shows the probative value is stronger in involving your particular accused.
Okay.
And we may disagree with that. I'll have to see hear what the state says about it, but
fundamentally,
and that's subject also to foundation, but we'll see.
Fundamentally, Your Honor, I just don't probative value. There has to be probative value towards a fact at issue.
Yeah, whether or not your client committed a murder.
But he doesn't admit to committing a murder. He talks about being arrested. And that is not at issue. He has been arrested. Nowhere does he say, I committed a murder on that video. If he said that, we'd be in a much different position. And he doesn't say that. And that's the whole point, is all he's saying is I was arrested.
Well, it also depends upon what else the state has to proffer in regards to that. And I don't know what they have. So, I mean...
Okay, well...
So I mean, like I said,
so
like a lot of these lyrics and songs are subject. That's why under the...
regarding...
Under 103, and I let them in preliminarily subject to foundation. So, and I'm still going to do that with your client and anybody else who may be featured in songs or videos. So,
regarding staying on the video, okay, and then I'd like to address the other the other video, the social media post as well. But staying on the video, if we were to agree that there's relevance of red YSL necklace and saying he was arrested, that is probative of something, then you have to get to the balancing. And it's prosecutorial need, overall similarity between the act, and temporal remoteness.
I'm just going to give you a heads up. You got about 10 minutes left, okay?
Okay. Well, so, Your Honor, regarding probative value and prosecutorial need, I'm going to read from Arrington v. State, and that is 355 Georgia Appeals 361, 2020.
One more site, 357.
355 Georgia Appeals 361, and this is
351 Georgia Appeals, is that what you said, or 355?
355 Georgia
I'm
Appeals
sorry, thank you.
361.
All right, 361.
And
All
it's
right.
2020 case. And on 364, it says, probative value of evidence derives in large part from the extent to which the evidence tends to make the existence of a fact more or less probable. Generally speaking, the greater the tendency to make the existence of a fact more or less probable, the greater the probative value. And the extent to which evidence tends to make the existence of a fact more or less probable depends significantly on the quality of the evidence and the strength of its logical connection to the fact for which it is offered. Probative value also depends on the marginal worth of the evidence, how much it adds, in other words, to the other proof available to establish the fact for which it is offered. The stronger the other proof, the less marginal value of the evidence in question. And probative value depends as well on the need for the evidence. When the fact for which the evidence is offered is undisputed or not reasonably susceptible to dispute, the less the probative value of the evidence. So,
You're talking about 403.
yes, I'm talking about 403.
Remember in Arrington, that was a 404 determination because you have prior bad acts, right?
Right, but
Okay,
that's
so
where, that's
Are you saying that I should look at this for the 403 analysis?
403 analysis, because that's,
This is giving?
in reality, that's where a lot of our 403 case law comes from, is 404B cases doing the 403 analysis. And the point I'm trying to make, and there's other cases that stand for this same proposition, but
It's a little different, and you'd have to agree with, because in determining other acts, you got to look at, in probative value, you're looking at evidence offered to prove the intent includes its overall similarity to the charged crime, the prosecutorial need for it, is temporal remoteness. And so when you're talking about that, it's a little different in terms of probativeness. Wouldn't you agree?
well, I'm just focusing on the 403, which is the second prong of the 404B analysis. And so I'm just isolating the 403 analysis. And, Your Honor, merely what I'm saying is the state in their discovery has handed over social media posts, hundreds, maybe thousands, several social media posts with Shannon Stillwell on social media, with Slat, with Snakes, with Quindarius Zachary, with other people. If the whole point of this is he's wearing a YSL necklace and he's wearing red, if that's what this is really all about, A, they could just show a screenshot of wearing the YSL necklace and that would equally prove the point. B, they could show any of these other pieces of evidence shared to discovery. They have a plethora of evidence that they claim ties Mr. Stillwell to YSL and to Quindarius Zachary. So the video, the playing of this video and those rap lyrics, which talk about robbing drug dealers, which talk about carrying a stick, are, it's completely unnecessary, and it provides no marginal probative value, because those same arguments can be proven through other means. And that's the whole point of that
Is
passage.
robbing the drug dealers and carrying a stick part of the homicide, the alleged homicide?
No.
Okay.
And,
Right.
and so danger of unfair prejudice, I think Mr. Steele talked about it. Obviously, references to robbery, and I think that's pretty self-explanatory. And essentially what it comes down to, the real value of this is not to show that there's a nexus, an evidentiary nexus to any of the offenses that Mr. Stillwell is charging, but the real value is it comes down to propensity. It shows a violent disposition. And you know, there's several cases. I know I want to preserve some time. Strong v. State, 309, Georgia 295. Thompson v. State, 303, Georgia 533. Moon v. State, 312, Georgia 31. Arrington v. State, which I already cited. And all these cases come after the change in the, and again, a lot of 403 analysis comes under 404B in our case law, and it comes after the change in propensity no longer being a permissible use of 404B, and then a 403 analysis to find what non-propensity value does this evidence contain, and then weighing it against the danger of unfair prejudice. So now, Your Honor, regarding the other video, I just want to...
Now, you have to point to which one you're talking about.
The one in the car.
Stillwell 1 or Stillwell 2?
Stillwell 2.
Okay, all right.
Okay, so I just wanted to read about unfair prejudice briefly. The term, this is from Baker, and it says, the term unfair prejudice, as it is used in 403, refers to the capacity of some conceitedly relevant evidence to lure the fact finder into declaring guilt on an improper basis rather than on proof specific to the offense charged. And that's citing to Old Chief v. United States, 519 U.S. 172. Generally, such improper bases for a finding of guilt include a criminal defendant's bad character or his propensity for violence. So,
But the lyrics in this case are not being offered to show propensity.
well, then let's redact them. Let's redact them. Then let's redact them. If that's not the point, let's take out references to robbery. Let's take out references to a stick, if it's that simple. But regarding this other video that I wanted to talk about, Your Honor, in Stillwell 2.
Got 3 minutes.
Okay, it's a, if you listen to the video, it's a express, I think it's an express statement to a popular rapper known as The Game. His name is Jason Taylor. I don't know the backstory behind everything, but it includes words such as, this is what got Biggie and Tupac killed. If you come here, I'm at your neck, okay? The Game, Jason Taylor, is nowhere listed in this indictment as a victim or as a witness, okay? There is no, and I'm not saying, maybe the state isn't planning on trying to introduce this. I don't know. All I know is it's provided in discovery. It has no direct link to any of the alleged crimes in this case. Again, it portrays Mr. Stillwell as a violent man, as a man who likes to settle his beefs violently, responds to violence. Strong v. State, 309 Georgia 295, prior bad act that shows propensity for controlling other people with violence and responding with violence when people don't submit, was too generic a motive and just bad character. So, and had very limited probative value compared to the great danger of unfair prejudice. Not only unfair prejudice, but a waste of time, and specifically in this case, when we're going to be dealing with the alleged shooting of a bus that another rapper known colloquially as Lil Wayne was on. It presents the possibility of confusion of the issues as well. There is nothing in this case that has anything to do factually with that video that depicts Mr. Stillwell and in others. But it does have great danger for unfair prejudice. It will encourage jurors to determine guilt based on those concerns that I read about from the Baker case, that I quoted from the Baker case. And for that reason, that fails the 403 balancing test, the danger of unfair prejudice, and other issues, as well as confusion of the issues, substantially outweighs any probative value, which is none in that video. We believe also, going back to the rap video, respectfully, Your Honor, that
Which
the,
rap video?
the
Which one?
Stillwell one,
Okay, all right.
that the scant probative value that Your Honor identifies in that video, that I respectfully disagree with, but the scant probative value is substantially outweighed with the danger of unfair prejudice in that video. And so for those reasons, we would ask that Your Honor rule both videos inadmissible in this trial.